Hello everyone, I hope you are doing well. In the last video, I have discussed in the first part about the history of patent system in India. In this particular video, I will start the annual part and we will discuss about the history after the Patents Act 1970. So let's start. Now, after the enactment of the Patents Act 1970, the citizens of India got an opportunity to develop processes. This led to a huge benefit in economic growth of India. Drug manufacturers manufactured drugs in bulk and sold at a cheaper price. Now, when India realized more about the intellectual property, now there were certain instances which helped India to think more about intellectual property protection. Now, the very first instance was the issue of turmeric patent in USA. Now, as you know that turmeric is a tropical herb grown in eastern part of India. Turmeric powder is widely used in India as a medicine, a food ingredient and as a dye. Now, United States awarded a patent on turmeric to University of Mississippi Medical Center in 1995 for its wound healing property. Now, an exclusive right was granted to sell and distribute. 2 years later, CSIR from India challenged the university regarding the novelty of the discovery. After that, US Patent Office cancelled the patent due to the lack of novelty. Now, the second instance was the issue of basmati rice patent. Basmati rice is a famous grain of India and it is well known for its fragrant taste. Now, this rice was well developed by Indian farmers over hundreds of years. However, a Texan company from USA obtained a patent for a crossbreed with American long grain rice. The US Patent Office granted a patent to the company on the basis of aroma and elongation of the grain on cooking. Now, since then the company can charge the farmers to grow the rice and not allow them to plant the seeds from the next year. So this made India to realize and file a petition in the US Patent Office. Now India says that most varieties of the basmati rice possess the qualities of the newly made grain. Therefore, the US Patent Office accepted the petition and cancelled the patent. Now the third instance was the issue of neem patent. W.R. Grace and the Department of Agriculture USA has first filed a patent in European Patent Office. Now the patent was a method of controlling fungi on plants using a neem oil. Now India filed a legal opposition of this patent because the extracts of the neem seed are known and being used for centuries in India. And the neem oil is used in curing dermatological diseases in human and in protecting agricultural plants from fungal infections. The European Patent Office identified the novelty and revoked the patent. Now, after all these instances, India realized that there are some drawbacks in our Patent Act of 1970, such as there was no protection for the products which are very famous for their superior quality from a particular geographical location. So, for example, like Darjeeling tea, basmati rice, etc. Secondly, now there is no mention in the Act about some plant parts such as turmeric, neem, which are well used as medicine from ancient times. Therefore, the dispute in case of turmeric, neem and basmati and the drawbacks of the Patent Act of 1970 made India realize to protect the intellectual property in a very strong way. Now, India joined the World Trade Organization WTO on 1st January 1995 and it became obligated to comply with the TRIPS agreement as a member of WTO. Now, TRIPS provided a 3-stage time frame of 10 years by introduction of mailbox facility, exclusive marketing rights and product patent for India to comply with the TRIPS agreement. Now, after that, India has made several efforts to comply with the TRIPS agreement, while also giving importance to public health and encouraging access to affordable medicines. Now, therefore, to comply with the TRIPS agreement, the Patent Act 1970 was amended several times. The first amendment was made in 1999, and the act is known as the Patents Amendment Act of 1999. According to this act, an inventor can apply for a product patent in the areas of drugs and medicines. Before this amendment, only processes were get protected under the Patent Act. Additionally, this amendment also provides grant of exclusive marketing rights (EMRs) for the distribution and sale of pharma products. Now, this act was came into force from 1st January 1995. Now, this act also involves the mailbox facility for a product patent. It means that a product patent can be filed between 1st January 1995 and 1st January 2005 under the provision of mailbox. And after 1st January 2005, the applications will get examined and will be granted patents after fulfilling the patent criteria. Now, the second amendment in the Patent Act was run in 2002. Now, this act introduced new patent rules 2003, replacing the earlier patent rules of 1972. Now, the second amendment act was brought into force from 20th May 2003. Under this amendment, major changes are made in this act, such as the protection term of a patent became 20 years for all inventions from the date of filing. Earlier it was 14 years. In section 3 of the Patent Act 1970, the list of non-patentable inventions was expanded, and it included traditional knowledge like medical treatments, computer software, business method in the list of non-patentable inventions. The definition of the invention mentioned in the section 2 of the Patent Act 1970 was expanded to introduce new words like non-obvious and useful. Now, this change was made because of introduction of product patents. Now, in case of biological material, disclosure of source and geographical origin was made compulsory to get a patent. Now, other significant changes was made, like provisions for concerning the convention countries simplified. Appellate board was established after that. The compulsory license provisions strengthened. And the procedure of patent become simplified, and the harmonization with the Patent Cooperation Treaty provisions. Now, the third amendment in the Patent Act was made in 2005, and it came into force from 1st January 2005. Major changes are made, such as product patent for inventions in all fields of technology, new forms of known substances excluded to prevent evergreening of the patent, rationalization of the opposition procedure, the grace period extended from 6 months to 12 months for filing a patent if it's published in a governmental exhibition, and in the introduction of pre-grant opposition and post-grant opposition, and compulsory for manufacture and export purposes. Now, patent rules. According to section 159 of the Patent Act 1970, the central government is empowered to make rules for implementing the Patent Act and regulating the patent administration. So, therefore, the Patents Rules 1972 were notified and brought into force with respect to with effective from 20th April 1972. Now, in 2003, new patent rules were made, and from 20th May 2003, it came into force, replacing the 1972 rules. Now, these patent rules were further amended by the patent amendment rules in 2005, 2006, 2012, 13, 14, 16, 18, 2019, 2020, 21, and the latest is 2024. And the recent amendment rules 2024 came into force from 15th March 2024. Now, some of the major changes made in the patent amendment rules, such as 2006, it reduced timelines and a fee structure based on specification size and number of claims in addition to a basic fee. 2012, criteria for patent agent exam qualification was introduced. 2013, it recognized patent office as examining authority and searching authority on international level for filing, searching and examination of patent along with necessary fees. 2014, it introduced a third category of applicant for small entities and revised the basic fee for filing a patent application. 2016, it introduced electronic communication to applicant, and applicant can withdraw their application using Form 29. And the timeline to put the grant of application has been reduced from 12 months to 6 months. 2019, patent agent shall submit all documents only by electronic transmission duly authenticated. 2021, it reduced the fee for patent filing and prosecution of for educational institution by 80%. And the latest and the recent amendment in the patent rules was made in 2024, and some of the amendments are: the timeline for filing the request for examination is reduced from 48 months to 31 months from the priority date. Introduction of certification of inventorship. The frequency of filing working patents was reduced from once in a year to once in 3 years. Okay, thank you very much, and thank you for watching.